So welcome, everyone. It's great to have you all here at this 4AP Council's webinar called Leveraging Geographical Indications, Benefits, Types, and Registration Essentials. My name is Fernanda Passoni. I'm the head coordinator of 4AP Council, and I'll be your host today. As you may know, 4AP Council is a non-for-profit research organization focused on the link between IP and innovation. Our mission is to identify the most relevant topics and produce empirical research by collaborating with a variety of academics, experts, IP organizations, and other stakeholders. On our website, you can access a range of free materials such as studies, summaries of relevant papers, recordings of our webinars, and podcast interviews, now featuring an AI special. And we also produce easy-to-digest content at our newly redesigned SMEs Corner, specially tailored for non-IP experts, SMEs, and startups. In the SMEs Corner, you can find an infographic on GIs, which has been recently updated with the latest developments in this area. We also have a new area on our website called IoT and Cellular Standards Made Simple, where you can learn about the benefits of standards and IoT across different sectors. If you want to learn more about this topic, go check it out. You can now follow us on X, LinkedIn, YouTube, and Instagram. Our handle is @4IP Council. There you can find out about IP news, resources, interviews, and future webinars. Now, without further delay, it is my pleasure to introduce our speakers for today's webinar. First, we have Javier Guillem Carrau. Javier holds a PhD in law on geographical indications and is a leading expert in geographical indications with over 25 years of experience, including roles at the European Commission and the EUIPO. He has published extensively on GI protection and now leads digital learning at the EUIPO Academy. We also have with us today Roberto a qualified lawyer with more than 15 years of expertise in intellectual property law. Since 2021, Roberto has been an EUIPO examiner and member of the Geographical Indication Collaborative Examination. Just a final remark for the audience, please do not hesitate to use the Q&A tool to submit your live questions. You can raise your questions at any time during the webinar and the questions will be addressed following the presentations. Javier, Roberto, the floor is yours.
Thank you, Fernanda. It's a pleasure being with you. And well, we'll try to tackle the objectives of our today's webinar by going through this program, okay? First of all, we'll try to describe what is a GI, what is the kind of protection that the geographical indications they have under the EU law, and why do we have this system in the European Union. From there, we will pass through the new concept of craft and industrial GIs to help you to grasp or to get the real deal, which is behind this intellectual property right. And we will try to explain to you which is the role of the EUIPO in this system. We will leave 20 minutes at the end for question and answers, so please feel free to, as Fernanda said, to write down them in the Q&A chat. And well, let's start with our objective. First of all, we'd like to think about your activity as consumers and as entrepreneurs. You see these products with some logos in the pictures because, well, when it comes to food and beverages, many consumers are looking for a guarantee of the quality and authenticity of the product. And most of the time, we are not able to distinguish them. The European Union has a system that is, trying to provide this to us. And this is what we are gonna do today to, well, as you see in the screen, we have these two symbols. I guess that you see this blur, no? Me too. Why? Because the objective of this session is to help everyone to keep on going with both concepts, PDO and PGI, and to know about the benefits that they have, no? So let's go with the first question. What is a geographical indication? And for this purpose, we need to understand first the acronyms. We have PDO for the protected designation of origin, and we have PGI for the protected geographical indications. The scope of protection is the same, but they are different concepts. And this is what I'm going to try to explain to you in the following minutes. So we have, first of all, the PDO. Here we are talking about a specific product which is produced, processed, and prepared in a defined geographical area. Let's see in a picture. Now, if we are talking about olive oil, we are talking about a PDO when the olives are from the area and they are processed in the area. So, for example, if we have this area called Kalamata, we will be talking about this PDO from Greece because the olives are already defined from the area, varieties from the area, and they are processed in order to become olive oil in the same area of production. This is a PDO, okay? The other figure, which was already mentioned, is the PGI. When we are talking about the PGI, we need to make a little bit a distinction in the second part of the concept. Let's gonna see it with an example as well. Well, we have a specific product. To produce this product, we need to do at least one of the stages of the production, processing, or preparation in a geographical area. This geographical area has a reputation, savoir-faire, characteristics that makes this product, well, acceptable to become a PGI. The example we would like to show to you is this cheese. As you see, the cow is on the territory, the milk is traveling to another territory, and we have the producer producing the cheese in this second territory. Okay, this is an example of a PGI. What are the differences? Well, as you have already probably grasped, when we are talking about the PDO, the red one, the symbol with the red color, everything is done in the territory. So from A to Z is done in the territory. On the contrary, when we are talking about a PGI, we don't need to have the whole alphabet. Let's say it's enough if we have done in the territory from B to Z. This is an important distinction in terms of the product, okay? But at the end, the process of recognition and the scope of the protection is the same one. You must know already that there's a rigorous screening at the EU level. The applications from the member state, from the producers, go through the member state, and from the member state to the European Commission. And the work is not only done when you want to register this PGI or this PDO, because there's a system of controls which is even over controlled by inspections from Brussels. Okay, so this is more or less how it works. The administrative process to get the logo is not easy. It has to follow this national phase and then the European Commission phase. There's a possibility of opposing to this process at national level or at the European level when you are from another country, not the one which originates the application. And let's say that is the system implemented for the PGIs and the PDOs since the very beginning. What more to say? It's important to understand who does what in this system. So the member state is to check the application. Then for the Commission is to check that the application contains all the information required by the regulation, for instance, the specifications, the standing orders, how to produce the product to be in agreement with the standards of the PDO or the PDI, and it is not vitiated with any error. This is the work of the Commission, and then it's for the national courts to verify that the decisions are taken by the national authorities on the minor amendments. Here we have several cases for those who want to study this further, the Comte and the Piadina Romagnola cases that are case law of the European Court of Justice that are explaining this with more detail. Okay, this is important to know. Then we need to go through the scope of the protection. Well, this is not only happening in Europe, it is happening at international level. This work on the protection of the GIs started with the Paris Convention in 1883. And let's say that this last element that completes this protection is the Geneva Act on 2020. It's important to be aware that we are now in a context at international level where there's the possibility of protecting the European GIs all over the world via the Geneva Act, which is an extension of the Lisbon Agreement. And how can we explain this special protection? Let's see. First of all, we are talking about intellectual and commercial property. We show here the case of the Gijona, which is a nougat from Spain, from Alicante, which was, a famous case that happened, let's say, some years ago, but there was one of the occasions when the Court of Justice decided to declare that the GIs were intellectual and commercial property. That means that you have been in a producer organization that is entitled to use the GI. You have the right or the exclusive use of this GI, and as well, you have the other side of the right, which is to prevent the third parties from using it. And this second part is even more, let's say, strong, than in other intellectual property rights. First of all, we need to exclude the generic terms because they are not going to be protected. I showed to you the example of the aceto balsamico di Modena, where it was said by the court and also by the regulation of the European Commission that the elements in this term that were non-geographical, let's say aceto and balsamico, were not protected. What is protected is the whole name, aceto balsamico di Modena. Okay? So generic terms are not protected. Okay? And then to what extent are we protecting the term? I show you the case of manchego. You will see here cheese that has the Spanish, it says Rocinante, and then you see a bony horse, and you see also windmills, and you see also like ships over there. And well, the court decided that in this case, that there was a clear evocation to queso manchego, which is protecting designation of origin from Spain. And this evocation went even through the figurative elements. So the extent of the protection is extended, allow me to repeat, by the figurative elements. Then we have another case here, which is about cheese again, and is the cheese Morbier. You know that this cheese has this black line in the middle, which is produced naturally with minerals in order to differentiate the ferment, let's say the type of evolution of the cheese that you have in the up part of the cheese from the below part. So there were other cheeses in the market that had this design with a black line, and the Court of Justice decided to explain to everyone that we have this evocation even when the design of a product may lead to consumer confusion, okay? as you see, the extension of protection is very wide. We have a third example here, which is the Campanilo. Here it was a bar that it was in Barcelona. So the preliminary ruling was asking to have some light here to the court. And here the court said that there was a clear evocation and the protection extends to services. So you cannot use Campanillo for a bar, and this is independently of the national and fair competition rules. Okay, why we have all the system working on? 3 clear objectives: to help the producers, to secure higher incomes for them, and to protect those entitled to use the symbol, the PDO or PGI logo. This is also a case, it's written in Mozzarella di Fuala Campana. And why this system is working? Why this system is working? Why? Because we have producers, we have stakeholders, and we have as well the consumers, the ones that I was talking at the very beginning, that are looking for authenticity and are looking for the quality. Okay, and this is all from my side. I'm going to pass the floor to my colleague Roberto. Roberto, please.
Thank you, Javier. Thank you also. Yes, I also from my side, thank you to the 4IP Council for organizing the today webinar, inviting us today to talk about this very, very interesting topic. Javier made a very nice introduction on what agriculture, we call it agriculture, geographic indications are, which includes, of course, food, spirits, and wines. Now we switch our attention to the craft and industrial geographical indication. What are they? A differentiation has been made between craft and industrial, which basically lies in the manufacturing product. The first one, for craft product, basically the manufacture process is done entirely by hand or with the help of some digital tools, but basically is by hand, where industrial products are more related to what is produced to an industrial level, even has a mass production product by using the machines. The need to create this new system, or let's say perhaps to update or to integrate this new rights with the already existing geographical indication system throughout Europe, was given by the fact that it was realized that at the national level there were a lot of products that could be eligible to such a protection, that were protected differently throughout the European Union member states, sometimes through a geographic indication system, like in France, for example, or with trademark, collective marks, or sui generis systems, for example, through the simple use. The need was also seen based on the fact that even throughout the world, those products are already protected, because in effect there is a lot of craftsmanship that has been created and developed during the centuries in specific geographic area, and then for that it was deserved a protection. So we created, I mean, the European Union has created this second layer of protection for geographical indication for craft and industrial, which basically goes together with what I just told you. We call it agri system. And as you can see from these slides, basically it's the same, because it's done, the protection is granted at union level. The products are different, but the protection is basically the same. It's unlimited in time, once is granted, the protection is for all life. And differently from trademark, for example, geographical indication registration doesn't need to be renewed. As Javier said at the beginning, for geographical indication, there are two type of rights, which is protected denomination of origin and protected geographical indication, PGI. The regulation enacted and already in force since last, since what? Yes, 1 year ago, basically. It was November, I think, 2023. Provided only for the protected geographical indication regime. This is why this slide is a sort of repetition of what Javier said, but just to highlight the difference. And so what is applied for craft and industrial GI is just what is needed in effect is to prove a geographical area, that the product is developed and is manufactured in a geographical area that has a quality or a reputation linked to that geographical area because of know-how, savoir-faire, of people being there, or of course the quality of the product that's been developed. So only or at least one production step needs to be done in the geographical area, and the geographical indication can be protected under this new scheme. We can now, okay, to make a point here, the European Union Intellectual Property Office has been granted the full responsibility to handle the registration product for craft and industrial geographical indication, differently from agriculture, spirit and wine products that is already, that is still with the European Commission and DG Agri responsibility for several reasons. So now we at EUIPO will be responsible of granting, of examining and granting registration for these rights, which will come from, when we talk about unitary IPR, is because the application will come from European Union member states. When we talk about Geneva Act, is those international registration that have already been registered in third countries will come into or will seek registration into the European Union through the Geneva Act, which is handled by the World Intellectual Property Organization. We will, of course, examine those applications and will decide whether to register them or not in the European Union. Then there will be the bilateral agreements. These are agreements that are negotiated by the relevant Directorate General in Brussels, in which the European Commission negotiated, in effect, several rights, amongst which intellectual property rights. There are three in this system. There will be three types of procedures. Those procedures will start as of 1st December 2025. So in 1 year time, we are preparing everything for the office to be ready to receive the first application on 1st December 2025. And that will be done. This can be possible through three different procedures. The standard one, which is basically what happens today with the agricultural product, which is basically coming first at national level. The application will be sent to the competent authority in the member states, who will do a first screening, and then will send it to us, to the EUIPO, who will carry out further examination to see whether it complies with the regulation, with the EU regulation. Then there is the direct registration. This is a new a new procedure which is not applicable for agricultural geographical indication. In this case, the applicant can submit the application directly to the office, so to the EUIPO, instead of going through the national phase. Why? Because some member states have expressed their wish not to analyze and not to examine this type of application because they don't have a set system, and because they don't have competency. So basically, they give the EUIPO all the competence to assess the examination. And then there would be the third country applications, which are basically application coming directly to the office through the from third countries. It would be possible to register a new name and further to that to request amendments. The office role then, as I was telling you, is complete from application until registration. This will also include the appeal to a negative decision on an application, and will be handled by our boards of appeal here. We will, of course, examine, publish for opposition purpose. If an opposition will be, we will also assess the opposition and will decide finally on the application. A new GI division has been created within the office, which will deal with the examination, as I told you, and publication, the decision. We will handle also the union register. The union register will contain all the geographical indication registered in the European Union. When I say all, I'm talking about craft, industrial, and agricultural geographical indication. We will basically, although the office languages are 5, so the examination will be carried out in a few languages, but we will have a translation system in order to communicate with member states in their own official language, and also with applicants directly when, as I told you, there would be this direct application. And we will be supported by the advisory board and also by, not written here, but a single point of contact in each of the member states who opted out to assist us with technical matters. Basically, what we do, and I can tell you within these slides, because today it's a convenient moment also to tell that the EUIPO signed a new collaboration agreement, and this is official, with the DG Agri. So we will be the back office also for the assessment, the pre-assessment of agricultural geographical indication applications for them, and also for the craft and industrial geographical indication application. What we do basically, we examine, we analyze the single document. The single document is the NERCL basically of the protection given or requested for the geographical name. And it includes, of course, the name, the type of product, the process of production, the link with the geographical area, and also an external link to the product specification. Our activities will be delivered or executed, I would say, by using IT tools developed internally. This is the GI portal. The GI portal basically is the portal towards the external world through which the applicants can file application and communicate with the office. Again, it will be in 24 languages, accessible to everybody, and to everybody, because it would be also possible to file comments on an application by interested parties who are not parties to the registration procedure. Then there would be the GI register, as I told you, that is the European Union register for geographical indication. Any data related to geographical indication registered in the European Union, and I'm not just talking about EU geographical indication, but also, as I showed you before, third countries or Geneva Act registrations or international registration coming from the EUIPO, and also by bilateral agreement. This register will be, it is already, but it will be also accessible when it would be improved with a new registration. Let's say we will be filled in with a new registration for craft and industrial product. Is accessible through the GI View. GI View is a database that has been developed by the EUIPO. At the moment, contains only the agriculture geographical indication register within the EU. And again, is accessible to everybody. It's a public information, and from there it's possible to see all the registration granted. I stop here. I give you a very high level overview of what happened at EUIPO in terms of examination of geographical indication. I pass the floor to Fernanda to see if there's any question to which we can reply.
Thank you very much, Roberto. And I would like to thank you both for the great presentation. Now let's open the floor for some questions. We already have some that came through. So I would like to start with a question for Javier. Can GI cover products with different presentations, such as fresh and fried fruit, for instance?
Yes, very good question. Thank you. Well, it happens a lot, no? That we think that we are protecting, for instance, beer. We can protect as well if this is a slide or is processed as a marmalade. Okay, let's say. Yes, the correct answer is yes, but we need to indicate. So, okay, when we are producing the product with, for instance, a slide or in another type of product, we need to indicate this in the labeling. Okay, we have guidelines about this produced by the European Commission. So it's important to take this into account in order to not to mislead the consumer. Okay. Well, the good practice here is as well to think this about this before registering the product, because like this, as Roberto has mentioned, we have a single document, and we can over there specify how the protected product can be commercialized. Okay, and this is the good moment to think about this is before the registration or after you need to do any modification of the single document. Well, it's good to introduce over there. Okay, so the reply to this is yes, you can use it, but you need to be respectful with the consumers in order not to mislead them, and you need then to do the correct and the proper labeling. Okay, there's a famous case which is sorbet champagne. When a famous supermarket, supermarket company, they produce this sorbet champagne, and they were producing the champagne with true very true champagne. So they were buying the PDO sparkling wine in France, and they were using this to produce the sorbet. And the European Court of Justice is explained in a preliminary ruling that it was according to the system, but it was up to the national judge to consider if, well, the percentage of the product, of the PDO product in the final product, it was enough relevant not to be used in the labeling of the product, or it was just a way of, catching the attention of the consumer, okay, in order to gain selling power with the product. Okay, and this is very important to be taken into account. In some countries, like in France, this is only possible with when the product is of the same category, okay? For instance, cheese, okay? And it should be in a sufficient quantity, okay? And then in Italy, for instance, what we have is like we can only use this in the labeling of the product if the producer organization authorizes, okay? So it's also depending on the country. We have also national rules for this.
Perfect. Thank you for
If I may add something to what Javier said.
absolutely.
Because yes, this is a very good question, in fact. And we also face it in terms of examination when we receive such an application. In effect, beside the consumer protection, that of course is very important, here we are also talking about the scope of protection of the geographical indication name. If a pear or an apple is just claimed, the name is for protecting that, the geographical name for protecting that type of apple, that I remember just to remember that what is protected is the geographical name and not the product itself. So not the apple, but it's the apple from, I don't know, whatever place. If we just put the fresh apple, it means that the cooked apple or the jam with that apple needs to be mentioned, as Javier was said, just as an ingredient, okay? But not as just as PGI or PDO product, where if the processed product is also claimed within the product specification or within the single document, then the protection is just PDO. This is a PDO. It's not just behind in the labeling as an ingredient, but it has to be there in the main label. So it's about the scope of protection as well.
That's great. Thank you for clarifying that, Roberto. And since you mentioned ingredients, there's another question here that is related, which is how is a GI product protected when used as ingredients in other products? Javier, if you want to take this one.
Yeah. Could you repeat it?
Absolutely. How is a GI product protected when used as ingredients in other products?
Yes, this is what we were talking about, no? I think that the protection extends, well, in any case, till the evocation, no? So the reasoning of the European Court of Justice with this sorbet champagne case was confirming, no, the extension of this exceptional protection for the GIs that the legislator in the EU has decided. Let's say, if the product, and this is much more clear in the new regulation, the regulation which has been just adopted, no? Any type of misuse, imitation, or evocation, even if the true origin of the product or services is indicated in the protected name, it's translated, transcribed, transliterated, accompanied by the expression of such as a style, type, method, as producing imitation, flavor, like or similar, including when those products are used as an ingredient, okay? So the extension of the protection for a GI, it covers even when the product is used as an ingredient. And this is literally the Article 26 of the Regulation 2024-1143, okay, which is the most recent version of the legal scheme for the GIs.
So this means that they can be used, okay, as an ingredient, but this has to be clearly stated, as I was saying before, in the ingredient labeling. So if it's strawberry from Mallorca, I don't know, behind or in the list of ingredients, it has to be written PDO strawberry from Mallorca. So it has to be clearly indicated. Also because that type of assertion can trigger the control. As Javier was saying at the beginning, once the geographical indication has been protected, is not as a trademark, that you have it and you can do whatever you want as an owner. Geographical indication is not owned by anyone. It's a public right that can be used by anyone complying with that product specification. And that's why there are controls. Because if that person doing jam with a strawberry from Mallorca and put PDO strawberry from Mallorca has been controlled, will be controlled, and is not compliant, then that would be an infringement according to the article that Javier was saying.
Thank you. That was very clear. And there's a question that came here. Could you please give us more details about the mentioned agreement between EUIPO and DG Agri for the examination of new application? Is it formalized in a document accessible to the public?
Yes, as I told you, it's official. It has been published. And the collaboration agreement, the memorandum of understanding, basically concern the EUIPO help, I would say, to the European Commission in pre-assessing the agri files. So yes, it's public, it's accessible by everybody, like it was before, but now it's even more, let's say, clear than before. So yeah, also because of this new responsibility of the office with craft and industrial products. So I think that we are going in the right direction also because we developed the skills during the last since 2018 until today. So we're talking about 6 years assessing our agri files. This will be continued with in collaboration with DG Agri plus the full examination responsibility for craft and industrial GI.
Thank you. I believe we are posting the link in the chat. And meanwhile, I will ask you, Roberto, another question. If a member state opts out, how can nationals from that state be supported in filing the application?
Right. I slightly mentioned this during the presentation. In effect, the procedures pretty complicated because, well, it's possible to, in effect, to go through the member states, but when the member states doesn't have the competencies, then the national of that member state should send an application directly to the office. The first stage will be played between the office and the applicant, but right after receiving the application, the office will get in touch with a single point of contact, as I was telling you. So this person will be designed by the member states in the opting out procedure. And basically it would be the point of contact between the office and the applicant at national level, through which the applicant can also have some assistance, okay, and have tools, so also to adjust it, to modify it, to amend the application in case the office will find some errors.
And another one, Roberto, that is perhaps connected to that, do existing names protected under national laws need to go through a second screening at EU level?
No, because in effect that was, and it's logical if we think about it, was a request by the member states, because, for example, in France, as I was telling you, the system has been already set during years, so they already have some geographical indication register for a while. In those cases, we will receive the request from the member states directly at the beginning, after 1st December 2000, starting from December 1st December 2025. Basically, we will just check formalities, okay, and they will be integrated into the system directly. For those already registered, it is worth to mentioning that apart from those already registered, there would be also the possibility of names that have been used in the commerce and using the market for years to be registered as well. But in that case, of course, we need a proof of that use. But they will come as pre-existing rights already. Okay, so basically the screening will be very light, I would say. Is not a second examination.
Yeah, that's much better to know.
Yeah.
Now, a question for Javier. Can the name of a variety or breed be registered?
Well, let's say in principle that yes, okay. If this is not confusing for the consumers, we have examples in the field of the fruits and vegetables, a lot of them. So in principle, yes, there's not any problem.
Okay. And what are the costs and benefits of GI registration for our young producer?
Okay. Let's say that costs, there's no fee, okay, for registering a PDO or a PGI, but you need to produce the documents, okay, the single document, etc. So you have some cost related to the proceedings, no? To produce the documents, to prepare them. You need many engineer, no, defining the organoleptic characteristics of the product or whatever. All this needs to be put in a document, and this, let's say that is the cost of the registration process. Okay. Then we have also, as we have said, because this is not only I register, I'm done. Okay. Then we need to control this, and we need to produce regular controls. So that's a cost with the controls. Okay. And this is normally taken on board by the board, no, responsible. We call this in Spain, for instance, Consejo Regulador, okay, and they are responsible for designating the control that is going to be applied for the products of the GI. Okay, so let's see, no fee for registration, cost of registration process, and cost of control process. Okay, benefits. Well, this is a long list. Okay, we are going to try to convince everyone. Let me recall that the name of your infography is for reasons, no, for joining, no, a GI or getting into the system. First of all, we have already explained the extension of the protection. I mean, it's wider than in other type of intellectual property rights. Have explained this very clear with the vocation cases. So this is the first reason. Second, at EU level, you have more resources for the promotion of your products. Okay, there's a regulation that allows this. Then we have a third element, and we are going here more on the economics and the politics. You have a localization of the product, which is very important. I mean, it has a sense also of, we were talking about warranty, authenticity, and here we are talking as well as about sustainability, no? We will have in the area an increase of the production. This is clear, happens everywhere when they have a PDO, a PGI. At the same time, they will create more local jobs, okay? Because it's like that, it happens. We have reports available in the DGAGRI website when they are explaining this with numbers and examples. We have an added value as well in the price of the product. Okay, the average price difference is normally 2.04. Okay, but depending on the products and the countries, for instance, in France, goes from a PDO wine or a, let's say, conventional wine, it goes to 240% of difference. So the average is high, okay? So we are talking for place about the added value to the product. Then there's another element which is very important in terms of competition, and is that the producers joining this type of, let's say, schemes, they are gaining a lot of power of negotiation with the other, let's say, elements of the food chain, okay? They are stronger, they can negotiate better, okay? And they get better prices and better negotiation position, no? With the other elements of the chain. And that's more or less that at the end, the benefit is that we are promoting a more sustainable agriculture that help us to keep our traditions. You know, Roberto mentioned before the terms in French, savoir-faire and terroir, and this is key, okay? These two terms are key in the scheme, and this is the benefit. And it's a public benefit for all of us, not only for those joining the schemes.
It's very important to highlight when I hear you both answering the questions that GIs benefit consumers a lot. And there's an interesting question that came up in the chat, which is everybody knows that Denmark was banned from calling its feta cheese feta, but what about mozzarella cheese made outside Italy? Why is it allowed?
This we can like start writing a PhD thesis on the feta cheese and another one in the mozzarella. Okay, it's a very good question because, well, feta cheese has a contradictory history because at the beginning we have a judgment declaring feta generic, and then the Greek producers, they were able to build another file showing that feta was not a generic term, okay? And that was key for the protection, let's say the inclusion in the registry of the feta cheese at that moment. That was attacked by other member states that were producing cheese at that moment, like Denmark or Germany. And the Court of Justice declared that it was clear from the file that there was not a generic element, let's say, in the protection of the feta cheese. Okay. That being said, the Commission has even opened pilots, let's say, infringement proceedings against countries which were allowing to commercialize this feta not coming from Greece. Okay. So this is concerning the feta cheese case, which, well, I have briefly summarized, and I said you can discuss for hours, no, on this product and the cases, and it's very attractive for the lawyers, no, because we can discuss from one side to change the views, etc. The mozzarella case is different, okay? I don't know if, Roberto, do you want to talk about the mozzarella?
Definitely, no problem. I mean, just again to add something to feta, an easier reply would be that feta is a registered geographical indication for Greece that cannot be produced in Denmark. That's it. Feta has been finally registered. So anything that is done outside that geographical area, I remember you that what is protected is the geographical name, even if feta does not refer to a geographical place, but is possible, like Prosecco, Grappa, what else? But there are several names that feta, which means slice, basically. It's possible to be registered as a geographical indication. So cannot be made outside, cannot be produced outside Greece, and not in Denmark. Mozzarella is not registered as a geographical indication. Mozzarella traditional mozzarella is a traditional specialties guaranteed, which can be made outside, like, sorry, I'm Italian, but I cannot avoid to make Italian examples, like pizza napoletana, for example. These are traditional terms. As long as the recipe is followed, you can make it whatever you want. Okay, these are the main two differences between the two. So that's why mozzarella itself can be made, but mozzarella is not mozzarella tradizionale even. If you see mozzarella, it's a generic name like aceto balsamico, as Javier said before. So aceto balsamico is produced in France, in Germany. And by the way, it was France and Germany that found to have this, mainly Germany, to have this declared generic, because they demonstrated that balsamic vinegar is produced by several years in other countries, and it's generic. So the same is for mozzarella alone. Then there's mozzarella tradizionale, and then there is mozzarella di bufala. Mozzarella di bufala campana, in that case, we are in DOP, so denomination of protected, so DPO, sorry. PDO. With all the different languages acronyms, I'm lost. I hope that we replied to the question.
Yeah, I think you both replied perfectly, and we have so many other questions, but I'm afraid we're reaching the end of our time. I would like to thank you both for your presentation and for answering our questions, the audience questions today. And I would like to thank you all for attending this webinar. A presentation will be made available on 4EP Council's website tomorrow. And I would like to remind you to do not forget to register to our upcoming webinar, Inventorship and AI, Defining the Human Role in Patent Law. And finally, I would like to remind you that tomorrow you will receive an email inviting you to complete a 1-minute survey about this webinar. And we will be very grateful for your feedback. So thank you again, Javier and Roberto.
You're very welcome.
Thanks to you.
Thank you for the invitation.
It was a pleasure. Bye, everybody.
Thank you, everyone. Goodbye.